Real people, real cases. This is Verdict Watch.
You're trying to walk away. At that moment, for the first 19 seconds of that video, did Miss White have any intent to assault and or batter Miss Sanders? That's step number one, right? Because this is an intentional crime. He has to prove intent. So for the first 19 seconds, right, prior to her actually walking away, did she have any intent to assault and batter Miss Sanders? Miss Sanders wants you to believe that she did because she had her hands in her pocket and she said she felt threatened. She says she felt bullied. You heard the words. The video said otherwise. The video shows Miss White standing there. Yes, there's an exchange of words. Words are not illegal.
Don't share the screen yet, Mr. Gill.
I was trying to get it ready. Yeah. Thank you, Your Honor. Good morning, Ms. Shannon.
Good morning.
So, you recall seeing the video presented yesterday in court?
Yes.
Okay, so I just wanted to bring the video back up and then have you walk us through it from your perspective, okay?
Okay.
And Your Honor, permission to screen share and reproduce the same video already admitted?
You may.
So, Matt, does this appear to be the same video that we watched yesterday?
Yes.
Before we get started, could you tell me the title of the video as it appears on the screen underneath the video?
My movie 29,
And what was the date?
November 24th, 2005. I mean 2025.
And the incident date was August 7th, 2021?
Yes.
Okay, what's the name of the video or the author of the video or not? Never mind, strike that. So let's go ahead and get started.
Can I have the pointer?
Sure.
No.
Oh, okay, not yet.
So no.
All right,
Okay, proceed.
thank you, Your Honor.
And
So,
please don't ask another question from the witness box. Every question comes from there or here, not from the witness box.
okay, so, I'm beginning the video. So, do you see yourself on the screen?
Yes.
And then just, could you identify which individual you are?
I am the individual on the left with the half up, half down here.
And you're facing the individual wearing a hat?
Yes.
And who's the individual wearing the hat?
Brianne White?
Okay, and is this the first time you guys were speaking at Spotlight on that night?
No, previously we greet each other.
Okay, so this happened some point after you made an initial greeting?
Yes.
And remind the jury what that initial greeting you made was?
A cordial hello.
Okay. And what do you notice or recall about Miss White's body language?
It was tense and threatening.
Do you see how her hands are positioned?
The video is dark, but they seem to be down.
Okay. And I'm going to continue the video. And do you recall what you guys are discussing at this time?
We are discussing her threatening me with an attorney over tweet from her defamation case.
Okay, and then did you start this conversation?
No.
Did you have any intention to continue a conversation with Miss White after your initial greeting?
No.
Okay. And I'm continuing the video. Now, I can see that your hand's up. Is that correct?
Yes, that is my hand movement when I'm explaining something.
Did you ever make any physical contact with that hand upon Ms. White?
Absolutely not.
Okay. And so I'm just gonna drag back a little bit. How would you describe your feelings at this point? Were you calm, upset?
I was upset. I thought it was ridiculous. She was threatening me with a defamation case over a tweet.
Okay. And do you recall what her attitude was? Was it the same? And I don't know why it jumps over these other people. Let me get it back. So do you recall her demeanor changing from how it was when she first approached you?
Absolutely, it was that of a bully.
Okay. And does she initiate physical contact with you at some point during this verbal discussion?
Yes, as you can see when I'm explaining, moving my hand like this, she grabs it.
Okay. And then can you describe what you see Ms. White doing with her right arm?
Grabbing my arm.
Okay. So at this time, she's made the initial physical contact with you.
Yes.
And was that with your permission?
No.
Do you feel that she had space if she wanted to back up?
Yes.
Okay. And then what just occurred right there? I saw a hand movement from you. What do you recall you were doing?
That was me pulling my hand out of her hand.
Okay, so can you kind of show the jury how she had grabbed you and then describe what you're kind of showing?
She grabbed my arm like this. I did like that.
Okay.
Pulling my arm away out of her hand.
And when you moved your arm in that motion, were you intending to strike her?
I absolutely did not strike her.
So your intention was not to strike her?
No, I'm 116 pounds. She's about 60 to 70 pounds heavier than me. I would not initiate a fight. I hadn't been in a fight in my life before that point.
Thank you. And resume. And then what happened there?
My body moved back because she pushed me off of my square.
Okay, so had you, at this point, besides removing your arm from hers, made any physical contact with her?
Absolutely not.
What did you notice, if anything, about her body language at this time?
It was aggressive.
Did she appear, do you recall whether or not she had her hands in fists or were they open palm? If you don't remember, that's okay.
I don't.
Do you recall if her hands were still in her pockets?
No.
Okay. And then I'm going to go back so we can play that again because everything happens fast. I'm returning to the 20-second mark and I'm going to play this next exchange. So what was that you just saw between you? Did you at that point make physical contact with her?
Yes, when she pushed me, I pushed her back.
So how did you push her? How did you make contact?
With this hand, and I pushed her like that. And as you can see.
No. Mr. Hill, can you please describe these things for the record?
Thank you, Your Honor. So you're describing that you're using your left arm after you've been pushed back to then push her back?
Yes, and because I'm a bit taller than her, and because my hand is a bit larger, her entire like neck and face area was just like in the push, just wham.
Would you have described that action by you as a punch?
No.
At this point, are you intending to get into a fight?
No, in my other hand, I'm holding a record that I was looking at.
A record like a CD?
An album, because Spotlight sells records.
Got it. Okay. And then what happens there?
She punches, well, as you can see, she punches me in like a pushing kind of motion that sends my body flying. And as you can see, midair, there's a record I was holding.
Okay, just because that happened really quick. So I want to see. Finish that. So how does she strike you?
Like, yeah. Like,
So with her right arm and a closed fist?
yes, she punched the crap out of me.
Where did she?
In my head.
Okay.
On the left side of my head.
What did you feel like your options were at that point?
Fight for my life.
Okay, and so is that what you did?
Yes.
And you didn't have any experience fighting previous to this?
No.
So it appears you go off camera. Do you recall whether or not you were standing at this time, or were you no longer standing?
Oh, she fully knocked me back, but I had stumbled, but I had managed to stay standing at that point.
Okay, got about 5 seconds left of the video. And you can't really see, but are you able to identify who the individual is in the bottom left?
That's the back of my head.
Okay, so that's you. And what are you attempting to do at this time?
Punch her back in the face
Why were you doing that?
because she punched me in my head.
And do you see Ms. White's left hand? And I'm going to try to show that a little bit. Right here. Are you able to make out her left hand?
Yes, her fist going towards my face.
Okay, and would you agree that at some point she was palming your face with an open hand?
No, I don't recall a palm in my face, just fists.
Okay, and at any point did she make any contact with you besides punching you?
Yes, she grabbed my hair.
Okay, is that something that you believe appears on this video? I'm going to play to the conclusion. That was it. So did you see her grab her hair on the video?
It was before that point.
Okay. At the 25-second mark. Play.
Yep. It was right in the corner when my head was in the corner and I was leaning forward like this. It's because she had my head like that. That's why I was leaning forward. But I think because of the way the punches were going, at some point she let go.
Okay.
But that wasn't the only time she grabbed my hair during that fight. She swung me by my hair, hurting my neck.
And does the fight stop when the video stops?
Absolutely not.
What happens immediately after the video stops?
The fight travels, and yes, picture frames were knocked over because we hit the wall, and then we fell on the ground in the bathroom.
Okay. And did anybody else participate in the fight?
Yes, the two girls.
Did you recognize them?
No, I was on the ground fighting Brienne, and the first girl came in and said, "Oh, hell no, not mine."
Sorry, Judge, objection to hearsay.
So what did you observe the other girls do? Not what did they say, but what did you observe them do to you after this video stops?
They started punching and kicking me along with Brienne, and it felt like I was in a tornado.
And were you able to tell which feet and fists came from who?
Yes, actually, because I saw Brienne standing over me and the other girl who was hitting me.
Did Ms. White make any contact with you apart from with her hands?
At that point, I can't recall because when you're getting punched and stomped, you start to go into a fetal position, especially with my hair still being pulled and I'm still getting punched in the head.
Okay. And who do you believe was punching you in the head at that time?
Brienne and also the new girl.
Okay. And then at some point, the fight is broken up though?
Yes, by security.
Okay. And then this all occurs in this general area, but towards the bathroom?
Yeah, in the bathroom area.
And then what happens after the fight finally stops?
Security escorts Brienne and the two women out. I follow them with security because security is like, we're gonna throw these girls out. Brienne hops into a black Escalade truck.
So you did exit the premises and it's your testimony that Ms. White was escorted out?
Yes, I wanted to make sure that she was kicked out of the club, and once outside, she got into a black Escalade truck with both of the girls.
Okay, so when you say both of the girls, you saw her exit the club and enter a vehicle?
Yes,
And other people entered the vehicle with her?
yes, one of the girls got in the driver's seat.
Okay, and it's your testimony that one of those girls was one of the individuals that was joining in the fight?
Yes,
Thank you. So, did it appear as though Ms. White knew those other individuals?
yes,
Thank you. Did you ever become aware that Ms. White filed a police report?
no,
And, how are you feeling after this incident?
I was angry. I was so angry, but one of the girls turned around and said,
Girl,
girl,
no, we're not gonna do that. How did you feel? The question is, how did you feel?
I felt pain. I felt physical pain. I felt embarrassed and I felt angry.
Did you continue conversations with Ms. White outside of Spotlight?
Yes, I screamed at her that she was a hoe ass
No,
bitch
no,
for
ma'am.
jumping me.
Thank you. Okay, so, do you recall whether or not there were video cameras outside of Spotlight that you saw?
No, not to my recollection.
Okay, and, after this, you, contacted law enforcement?
Yes.
And did you ever at any point change your mind about wanting to prosecute?
No.
Did you want the case to come back so much later?
Relevance.
I think it's relevant, but
It's not.
I'll withdraw that. Your Honor, I have nothing further.
Okay. Cross-examining.
Ms. Sanders. Yesterday when you testified, when you testified, even before the defense counsel played this video, that was your opportunity to tell the jury everything that happened on August 7, 2021, correct?
Yes, but I was
Is that
upset.
a yes?
Yes, I was visibly upset,
That's a
however.
yes, correct?
Yes,
In fact, you were not only questioned about what happened on August 7, 2021 by the prosecutor, but you were questioned about what happened on that day by me too, correct?
yes,
Okay. And it wasn't until you sat in the courtroom and you watched Ms. White testify, you remember her testimony, correct?
yes,
Okay. You remember her describing what happened on the video, correct?
yes.
And so now we learn today more facts about what happened that night, correct?
Typically, that's what happens.
Okay, because you never said yesterday anything about Miss White leaving the club.
I was
Let me
not.
finish
No,
my
no,
answer.
no. Okay. Let Mr. Basant finish his question, and then you're gonna answer, and then you're gonna let her finish her answer.
Absolutely, Judge.
All right.
You never told this jury anything about Miss White leaving the club and hopping in a black Escalade with the two girls that allegedly jumped you. You never said that yesterday, did you? Yes or no?
No,
You never mentioned about you leaving the club, following Miss White and just screaming at her, "You hoe ass bitch for jumping me." You didn't mention that yesterday, did you?
no.
Okay. And I don't know if you remember, but I do. The next morning, when you spoke with the police and told the police what happened, you never told the police anything about Miss White hopping in the Escalade with the other two girls, did you?
That is not the police report. That is a conversation between me and the detective. The police report that I reported was between me and a female officer over the phone. That is why probably my signature isn't on that document because it's not the
It's
police
a lot
report.
of extra stuff, and
Okay.
I addressed you yesterday outside of the presence of the jury. Today I'm addressing you in the presence of the jury. We're gonna answer the question that is being posed to us. Mr. Basant,
I'll rephrase the question. Ms. Sanders, when you first spoke to the police over the phone, and you told them about what happened the night before, did you ever tell the police about you following Miss White and seeing her hop in a black Escalade with the two girls that allegedly jumped you at the club?
Yes,
Okay, but they just didn't put that in that statement that you read yesterday.
that is not the police report. That is a conversation that the detective called me after.
All right, so the police got it wrong, right?
That is a conversation between me and the detective, not me and the officer I spoke to.
And when you called the police the next day to tell them what happened, they didn't put anything in there about, in that statement that you read, about you saying that you followed her out of the club and said, "You hoe ass bitch for jumping me."
Considering that document is the conversation between me and the detective who called me after I filed my report, that information would not be in there.
Okay, so the police got it wrong. And in the video, every time that Miss White is allegedly pulling your hair, grabbing you by the hair and swinging you by the hair, because that's what you said yesterday, that's off camera, right?
Yes.
Okay, and if I may, Judge, if you can just, I just wanna. Ms. Sanders, I just want to play real briefly the first 19 seconds of the video. And I'll pause it right here. For 19 seconds, did you watch that video?
Yes,
Miss White is standing with her hands in her pocket, correct?
one of them is in her pocket.
Ma'am, Miss White, it was from the same video that I saw for 19 seconds. Is her hands in her pocket? Yes or no?
Her hands were in her pocket in the beginning and one came out of her pocket to grab my arm.
Okay. But for the first 18 seconds, her hands are in her pocket, correct?
Yes,
She's not pointing at you, is she?
no,
She's not touching you, is she?
no,
She doesn't have her fist out, balled up or anything of that nature, does she?
no.
And it's not until Miss White begins to literally walk away that you say she's then grabbed. Let me finish. It's not until.
Take your.
All right, for the jury.
Stand. All right. Next. Sometimes I probably overstep when I'm in jury trials, and I might be overstepping right now. Because I could leave your witness to her own devices to destroy the people's case, plummet it to the ground, let it crash and burn. But I'm not wired that way. Oftentimes when the witness thinks they're helping, oftentimes when the witness thinks they're doing something, it could be because she wasn't in here when I read that jury instruction about how to judge the credibility of a witness. When I read the jury instruction about how to read the body language of the witness, when I read the jury instruction that says, do they seem to evade the questions or argue with the lawyers? Maybe it was because she wasn't in here when I read that jury instruction. Now I've asked you to only answer the questions and not try to throw in that extra information. I've asked you that. And you continue to throw in that extra information that you think is helping your case. You think is helping your case. You keep on trying to throw in that extra information. That jury instruction is going to be read again. It's in the final instructions. That same jury instruction is in the final instructions. How do you judge the credibility of the witness? Did they seem to evade the questions or argue with the lawyers? Right now, you're doing a great job of evading the questions and arguing with the lawyers. And I like cases to be decided on the facts of the case and not on other things. But you're doing a great job of evading the questions and arguing with the lawyers, disregarding the court's instructions, throwing in information you think is helpful, causing me to have to strike your statements in front of the jury. So I'm just admonishing you. I'm not going to send them out again. But I would just take a pause and a breath and try my best not to evade the questions and argue with the lawyers and not to ignore the instructions of this court, because I don't do well with that. And so then I'm going to keep correcting you in front of the jury. So do Do we need a short break? Now, you can't talk to her during this break. If I take a break, Mr. Hill, it is prohibited. Okay, do you need a break?
No,
Okay, all right, we're gonna bring that jury back in. Stop talking to her, Mr. Hill, stop giving instructions, stop giving encouragement. Listen, it's inappropriate. Stop it. Now, this was a courtesy that I gave right here, this was a courtesy. I don't need any assistance from you. This is a courtesy, but I'm not gonna send my jury out again. Every other correction, every other admonishment, every other striking of the testimony, it is going to take place in front of that jury. All right, the next time we say all rise for the jury and you stay sitting down, I'm gonna hold you in contempt of court.
sorry, I wasn't paying attention.
To pay attention,
It's a lot of.
pay attention. There's nothing going on but this court, this case, and these instructions. Let's bring the jury back in.
All right, for the jury.
Ready to see it. Also, you make the changes.
Just following up on actually one of my last questions. And so, Ms. Sanders, even from the video that was watching, and as we're pausing literally right here at this moment, at some point, Ms. White begins to walk away from your pointing and standing right in front of you, correct?
Yes,
All right, you don't move, she moves, right?
yes,
And it's at that point that your testimony is that that's when she takes your arm and swings it away and then pushes, correct?
yes.
There's no further questions.
All right, are you gonna use the video again?
No, Your Honor.
All right, let's stop sharing the screen and then, is there any,
About 2 follow-up questions, and that's it.
okay,
Did you, when you spoke to police, did you answer the questions that they asked?
Yes,
And were your responses consistent between all of your interactions with police and here today?
yes,
If the police asked you about what happened after the fight, would you have told them?
yes.
Nothing further.
all right, thank you, ma'am, you may step down. Anything further on behalf of the people?
No, Your Honor.
All right. Then are we ready for closing argument?
Ready.
Are you ready for closing argument?
The defense counsel ready, yes.
All right. Okay, ladies and gentlemen, as I instructed you yesterday, if you're going to take notes about the closing argument, please put a line now, and label this next section closing argument so that you don't confuse it with, evidence. Closing arguments is not evidence. On behalf of the people, you may proceed.
Thank you, Your Honor. And again, I appreciate everyone's importance, attention and time. This case is not a murder trial, but it's important. And it's important to, both sides that we, uncover the truth. And I know that we've seen a lot, heard a lot, and there's a lot to unpack. And I have some questions that were raised, throughout this process, and I just wanted to kind of walk you through some of my thought process. And I know that a lot of people may have preconceived notions, but I encourage you to go in there, have an open mind, let everybody say their piece, and see if we can come to a consensus, whatever that may be. Now, I believe Ms. Shannon's testimony was extremely consistent. She told the police what happened in the fight. She sounds like she was interviewed by a detective. It was consistent. There was a statement that was taken over the phone. And then now she's come to testify. It's not like she's contradicting herself. It's just that additional details, the more you talk about it, may come out. If she's testifying as to what happened, and then there's another witness that comes on in the video, that's why you have a rebuttal witness to essentially respond to what's come out. It's not like she's adding or inventing. I don't believe that any of that took place. I believe she's explaining and telling her side of the story. Now, I think if you put yourself in the positions of either party, this can obviously be an emotional situation. We're all human, and going through this experience can be traumatizing. And it's not easy to go back and think about it, especially if you feel like you're on the defensive. And I'd like you to keep that in mind when you're thinking about and evaluating the testimony that you've heard. Do you think that, the body language was natural for somebody that's upset, or do you think something else? And I think that, it's very consistent. And I think that if we were in that same position, we might feel very similar. Now, I thought some interesting things were raised by the defense that gave me a little bit of pause. First of all, it sounds like from the testimony of Ms. White, previous to this night, unbeknownst to Ms. Shannon, she was already plotting what sounded like a civil defamation lawsuit against Ms. Shannon. That was her testimony. She was upset about social media posts. Now, Ms. Shannon comes into the Spotlight Bar. This is months after she's posted something in allegedly in defense of her friend, and she congratulates her. Great job, good to see you, whatever. And that's it. And she walks away. And the testimony is that Ms. White was with multiple people at that time. Some of those are mutual friends. And that's all Ms. Shannon has to say. She's not talking trash. She's not saying something about this old incident. That's water under the bridge, seemingly for Ms. Shannon, but not for Ms. White. She was upset about this incident. She's got lawyers in Atlanta. She's been plotting a defamation lawsuit. So she sees Ms. Shannon, who she's already unhappy with apparently because of what she's put on social media, and she doesn't like that. She thinks she can just be friendly to her, right? Who are you to try to talk to me and be nice when, you said this on social media? Maybe we feel the same way, but Ms. Shannon's intention wasn't to seek her out and to fight her. No, Ms. White's intention was to, after the initial conflict or the initial friendly, cordial discussion, to reapproach her. How dare you talk to me? She goes up. We don't see how she goes up, how she approaches you. All we see is a conversation that's already begun. And, I think that Ms. White shows a lot of awareness of what she's doing. She's got her hands in her pockets. Obviously, that's, not a fighting position. But in that discussion, it's almost like she's trying to appear that she's not the aggressor. Why are your hands in your pocket anyways? That's just an unnatural thing, in my opinion. And, it happens fast. We saw 30 seconds of video. There's hand motion. Clearly, Ms. Shannon becomes upset at some point, and you can see that she's verbalizing her passion, but she doesn't touch her. Watch the video closely. Her hands never make contact with Ms. White. They do not. Now, you can see on the video, they're not surrounded. If Ms. White wants nothing to do with her, first of all, she didn't have to come up and call her out and try to say, you can't talk to me. You're not worthy of talking to me, basically. And, she could have backed off. She could have gone any direction. She didn't need to disengage by going through Ms. Shannon, but she, didn't like the conversation. She said she wasn't going to argue because she's an adult. So, she's trying to get through her and push her to the side. She grabs Ms. Shannon's hand. That's the first physical conduct. And Ms. Shannon's like, now you grab me, so I'm going to pull it back. And it's not Ms. Shannon pushing her first. No, it's Ms. White clearly on the video pushing her where you see Ms. Shannon step back. And then she responds with a push, right? So she's pushing her back. What Ms. Shannon has shown is self-defense because she's proportionally responding to the physical conduct that Ms. Shannon's exhibited first. And she didn't want the fight. She had no intention. She said at that point, she felt she had no choice. She was going to fight for her life. She never would have tried to fight Ms. White. She didn't want any of that. She wanted to just enjoy her night with a separate group of people. And, it's curious. DPD, according to, I believe, Attorney Bassan's statement, I'm not sure if this was part of the testimony, but DPD, suffice to say, didn't get the video. It would have been nice if we saw the video in the club without, a stop and start point, such as we did. Now, there was some testimony from Ms. White that I believe was a little bit inconsistent. She goes to the club the next day. This video is airdropped to her. Did you ask for a certain portion? No, this is just what they gave me. And then later on in the testimony, well, why didn't you get the video from out front? You're building a defamation case. Is she slandering you out front? Did she call you names? Wouldn't you want that? No, I was only looking for the video that was part for my self-defense. So I felt like, as soon as I got the portion that was most beneficial to me, that's all I wanted. Why? What is missing from, at a minimum, twice the length of the fight? By Ms. White's own testimony, this continued on for another 30 seconds. Ms. Shannon believes it continued on for a couple more minutes. It is deeply disturbing that we do not have that video. And, I wish we did. And I think that it would be useful for everybody to do it, but I don't think that we're naive to think that Ms. White's testimony was incredibly credible, that essentially the video ends, she walks up calmly, she goes and says, I'm gonna pay for all these broken things. If you were just in a self-defense situation and someone attacked you, why are you offering to pay for the property, right? You were the victim according to Ms. White, but no, she volunteering to do it. You can see in the fight, frankly, the disadvantage that Ms. Shannon had in that fight. And I think that it's obvious Ms. Shannon took much worse of that. Now, my argument as to why you should convict onto assault and battery is under two different grounds. The first is somewhat technical, but it is the law. Now, read the jury instruction for assault and battery, it's going to be an unwanted physical touching without someone's permission. It doesn't have to cause injury. Now, Ms. White intended to make physical contact with Ms. Shannon when she tries to push her and walk through her. Technically, that's an assault and battery right there. And then everything that happens after is a byproduct. That's the start of the physical conduct that leads to a fight. Furthermore, Ms. White's the first one that physically pushes her, and you can see the reaction there. Now, you've heard testimony. Testimony is direct evidence, and we heard what happened after the fight, and they're not perfectly aligned, but they're fairly consistent. And we've got testimony that Ms. Shannon ends up on the ground. She's getting beat by multiple people. We're not sure who lands all those blows, but we're sure that Ms. White was one of them, and we're sure that she was punching her in the face when she's on the ground. Now tell me if that was proportional to what needed to be done. I believe that this fight was essentially over when she's on the ground, and you can walk away. Why don't you walk away then? Why don't you go say you're gonna pay for it and leave? You had your opportunity. No, you're gonna get down and continue the beat down. So that was an assault and battery right there. That was excessive, unnecessary. The opportunity to end the fight had already happened. She's down, right? If you're in boxing, they're waving the flag, right? You don't jump on her. And I think that, we need to keep an open mind and think, why are the answers that we're being given what we're given? I don't know how large everyone's elementary school is, but I remember the people's at least first name. And it's kind of confusing when I don't know these people that jumped in the fight. I never saw that, but the testimony is they drove you home, right? Is she telling the truth? I mean, I can see why she might want to lie to protect her friend. She don't want her friend to get in trouble. She participated in that, and maybe that honor is misplaced. But what I took from it is she's not telling the truth. So if she's not telling the truth about this, what else am I questioning in her version of events? I think Ms. Shannon was incredibly consistent, and I'm asking you to take your time and discuss amongst yourself and come to a guilty verdict. Thank you very much.
Yeah.
Thank you very much, Your Honor. And, ladies and gentlemen, Jerry, I just want to thank you for your attention, the kind of attention for the past 2 days, listening to this particular case and the facts and evidence and the witnesses who testified. At the end of the day, ladies and gentlemen, all Ms. White asked for is justice. That's it. That's all she wants. She wants a fair shake and she wants justice. And in order to do so, unfortunately, she was charged in this particular case, but as I told you, simply because you're charged, you're not only guilty. And so you are the trier of facts. You make that determination. And so that's why we have these trials. That's why we have these witnesses. That's why we have these videos. And so going back to August 7th, 2021, you've heard two sides of the story. You've heard Ms. Sanders give her side of the story. You heard Ms. White give her side of the story. Now, the trier of fact, you have to deliberate and determine based upon your own, common sense, what you've heard and what you saw, who's telling the truth, what's more logical, but more important, did the prosecutor meet their verdict? And so the prosecutor has to prove beyond a reasonable doubt that on August 7, 2021, as Ms. White is sitting there with her hands in her pocket, looking at Ms. Sanders, pointing at her, yelling at her, arguing with her, and then you clearly see her try to walk away. At that moment, for those first 19 seconds of that video, did Ms. White have any intent to assault and or batter Ms. Sanders? That's step number one, right? Because this is an intentional crime. He has to prove intent. So for the first 19 seconds, right, prior to her actually walking away, did she have any intent to assault and batter Ms. Sanders? Ms. Sanders wants you to believe that she did it because she had her hands in her pocket and she says she felt threatened. She says she felt bullied. You heard the words.
The video said otherwise. The video shows Miss White standing there. Yes, there's an exchange of words. Words are not illegal. But there's absolutely no actions on her part whatsoever to suggest that I want to fight this woman, that I want to hit this woman, that I even want to engage this woman physically. And what did Miss White say? Miss White said I was embarrassed because this is a public place with a ton of people around, right? She said I was embarrassed. She said, so I started to walk away. And then that's when she reached out and prevented her from walking away. And she said, I pushed her off. And then at that point, you saw what happened. And I told you in opening statements that not only are you going to hear about what happened, you're going to see what happened. And you saw what happened on August 7, 2021. So the question I asked this jury is, number one, did Ms. White have any intent whatsoever to assault Ms. Sanders? I think it's the complete opposite. Here's what I think, and I'm just going to be candid. Ms. Sanders said that she had 2 encounters with Ms. White. The prosecutor wants to argue, well, this video might not be a full video, this is edited. Let's just go off of Ms. Sanders' testimony. Ms. Sanders testified, I'm sorry.
I just wanted to correct it, it's Ms. Shannon.
I keep saying Sanders. I truly apologize for the record, Ms. Sanders. I apologize.
Mr. Hill made a snap in his closing argument, he's been wrong in this room.
Yeah, well, I'm sorry.
I apologize, I didn't correct it.
But Ms. Shannon testified that there was at least 2 times that she encountered Ms. White on that. She said the first time everything was fine, everything was cool, there was no problem, there was no issues, everything was coordinated. So let's assume that that part of the video is missing, right? It has absolutely no relevance to whether or not Ms. White had any intent to assault and battery. The portion that you saw is why we're here. The portion of that video that you saw is why we're here. That 30-second video is why we are here. That 30-second video is why you're going to go back and deliberate on why we are here in terms of whether or not Ms. White is guilty or not guilty. So the argument about whatever happened beforehand doesn't really matter. But the focus about that second encounter, when you saw Ms. Sanders upset, you saw Ms. Shannon's upset, you saw Ms. Shannon pissed off, you saw Ms. Shannon arguing, you saw Ms. Shannon pointing, and what happened? What did my client say? She struck me in the face, and you saw these videos, you saw the exhibits, swollen eye. She said she wished down and scratched me all the way down. I had a scratch on my chest. You saw what happened, right? We're not making this up. She's not lying. Her story is consistent. And let me tell you something. When you're telling the truth, your story is always going to be consistent. Because you ain't got nothing to hide. You ain't got nothing to lie about. I'm telling you what happened, right? We didn't get that from them. We got stuff that was all over the place. Even when she called the police. Mind you, the next morning, after my client had already done so, but she claimed she didn't know about it, when she spoke to the police, different stories. When she testified yesterday, different stories, inconsistent testimony. The prosecutor puts her back on the stand. Now we're hearing more information about that night that we never heard yesterday and that we never heard when she told the police on August 8th the next morning. So who do we believe? Ms. White was consistent. Ms. White told you what happened. She told you how it happened, and she never left anything out. But even if you don't believe Ms. White, believe that 30-second video and you make the call. Because Ms. White has what the law calls an ability to defend herself as well. That if you're placed under the imminent threat of harm, that if you're placed under the imminent threat of a physical assault, guess what? You can fight back as well. But here's the problem with Ms. Shannon. What you can't do is start a fight, lose that fight, get mad, and say, I want justice. That's not how the world works, unfortunately. That's just not how the world works. If you're going to start something and you can't finish it, that's not Ms. White's fault. But Ms. White has every right to defend herself, and that's exactly what she did. These two other people, these magical two other people, whoever they are, has nothing to do with Miss White in this particular trial. The remaining portion of this video that Miss Shannon claims shows her being drugged and by the hair and tossed around and stumped around. You saw what happened. Ladies and gentlemen, I ask that you apply common sense. The judge is going to instruct you in the law. I told you that the prosecutor, if he cannot meet all the elements, you have to find Miss White not guilty. The prosecutor has failed to prove beyond a reasonable doubt that my client committed the act of assault and battery, and I ask that you find her not guilty. Thank you.
Any rebuttal?
Extremely briefly. So I'd just like to clarify that in my opinion, she's not walking away, she's walking through it. Right? There's a lot of different ways you can go to walk away. And making physical contact and pushing someone to the side is not the most convenient way. That's the first physical contact. Attorney Bassan's trying to tell you that the first encounter has no relevance to the fight, but the first encounter ceased cordially, and Ms. White, by her own admission, approaches with the intent to basically call her out. That's her mindset when she goes. So what's her intent? I'm going to tell you, how you can and cannot talk to me. And did Ms. White, or there you go, Your Honor. Did Ms. Shannon stand up for herself and did she argue back? Sure. Did she have any intent to fight her? Absolutely not. I believe that Ms. White maybe had those intentions, or she was definitely ready. She was clearly ready to fight. And I think that when you put yourself in the perspective of Ms. Shannon, what would you have done different, right? If you're defending your friend in this mutual argument, let's argue about it, or let's just not have anything to say. Ms. White wanted to continue that conversation, and then when she was done, she wanted to end it physically. And then it went from a push to the side, to push back and forth, to fist flying. And there was no inconsistency between the testimony that Ms. Shannon provided way back then, yesterday, or today. She's added details. She hasn't contradicted a single thing that she said. And there were, I think, as I've already pointed out, some inconsistencies and issues with the testimony of Ms. White, which I think should give us pause as to credibility. If you believe Ms. Shannon, and you believe that the initial contact is by Ms. White, and you believe that she's telling the truth with what happened after, I'm encouraging you to find that this defendant guilty beyond reasonable doubt. Thank you very much.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer said something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but it is a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I may have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or to express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, a person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes, ladies and gentlemen, the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about other things, you may simply accept the part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. So for example, if you look outside, you see rain falling. That is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the element of a crime. In other words, you should consider all of the evidence that you believe. The defendant is charged with the crime of assault or assault and battery, and the prosecutor must prove the elements as follows. Let me see one of those subjects. Prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed an assault or an assault and battery on Taylor Shannon. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Taylor Shannon's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Taylor Shannon or to make Taylor Shannon reasonably fear an immediate battery. The defendant claims that she acted in lawful self-defense. A person has the right to defend, a person has the right to use force to defend herself under certain circumstances. If a person acts in lawful self-defense, her actions are justified and she is not guilty of assault or assault and battery. You should consider all of the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember, to judge the defendant's conduct according to how the circumstances appear to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had the right to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself. But you may also consider how the excitement of the moment affected the choice that the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August the 7th, 2021, within the city of Detroit and within the county of Wayne. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off all of your cellular phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, Although you should try to reach agreement, none of you should give up your honest opinions about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin your deliberations, or questions about instructions that arise during your deliberations, you may submit them in writing in a sealed envelope to the court officer. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me for any reason about anything while you are in the jury room, please have your foreperson write a note, place it in the sealed envelope, and give it to the court officer. Do not write on the outside of the envelope. It is not proper for you to talk directly with the judge, the lawyers, the court officers, or other people involved in the case. You're gonna write a note, you put it in an envelope, slide it under the door. There will be an officer outside of your door at all times. You're not gonna knock on the door and say, "Hey, officer, we got a note." All right, gonna put it in that envelope, gonna slide it under the door. That means anything. We're hungry. We wanna go to lunch. Write a note, put it in an envelope. Hey, we don't have any water. Write a note, put it in an envelope. Hey, we need the bathroom attended to. Write a note, put it in an envelope. Everything that you need from me, write a note, put it in an envelope. As you discuss the case, you must not let anyone, even me, know how the voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside the jury room. That means if you're deliberating and you take a vote and then you say it's 4-2, and then you keep talking, you take another vote, and it's 4-2, and you keep talking, take another vote. Now it might be 5-1, or it might be 3-3. And then you say, I don't think we're gonna reach a verdict. Write the judge a note, however you wanna word that. We can't agree, nobody's moving, we can't reach a verdict. But do not say, and the vote is 3-3, 4-2, 5-1. Don't tell me. Don't write it on the note, because I have to read the note on the record. You cannot allow anyone to know how the voting stands until I declare a mistrial or until you have reached a unanimous verdict. When you go to the jury room to deliberate, as I indicated earlier, you may take your notes. If you want to look at, if you want to look at any of the exhibits while you're in the jury room, ask for them. All of the printed exhibits can be sent to you in the jury room. However, if you want to view the video, that viewing is going to take place in the courtroom. It can take place as many times as you want it to, as long as you want it to. Because we have to keep pushing play, I can't let you watch it without us in here with you. But if you want to have discussion about it, like while you watch it, I can potentially clear the courtroom while we pause it, and then if you want to see it again. But there's no mechanism for you to watch it in the jury room. I know you've seen the lawyers showing it on their laptops. There's no mechanism to make sure that that laptop has nothing on it but that video, so I can't send anybody's laptop with you. So if you want to watch the video, you can watch it as many times as you want. We can slow it down, we can't speed it up, but we can slow it down if you want, we can pause it, all those things, but that will take place in the courtroom. You may return a verdict of not guilty or guilty of the crime, and there has been a verdict form prepared for you. That verdict form reads as follows. The court caption, people of the state of Michigan versus Breanne Shanice White, the case number and such. And then it reads, we the jury in the above captioned case by unanimous decision find the defendant, count one, not guilty, or guilty of assault or assault and battery, so say we all. There is going to be one of these in each book. However, only the foreperson needs to fill it out. So everybody else, I mean, you can fill it out and take a picture, I mean, you know, just know. But only the foreperson, we need you to date it, print your name, and then sign your name. I believe that concludes the court's instructions. Are the people satisfied?
Satisfied, Your Honor.
Defense counsel satisfied to what?
I'm sure all the members are present. I just forgot everyone people think I'm cheating. I'm being probably, you know, mixed up. I don't mind. In fact, we found out that the friend that we just made was numbers.
Your numbers.
So, yeah, okay, we're gonna thank and excuse. We're gonna thank but not excuse. You're not set. Thank but not excuse. You have to put your phone number down and leave your notes while, if you are to be called back, then you'll have your notes. The remaining jurors, you are the jurors deliberating. You're gonna write your phone number so we can have a number that we can reach you at. And so what was funny was that juror number 5, her number fell on the floor. Remember, she didn't want to, she was trying to get she was trying to get me to make the number yesterday. And if I hadn't seen it fall on the floor, her number, it would have been like I intentionally didn't pick you, but I didn't do that. I didn't do that. All right. Oh, did I show it up? I'm sorry. Yes, okay. All right, so we're gonna let juror number 7 go, and then everyone else is gonna deliberate. Also, juror number 7, you can go ahead and cash in your voucher, but remember, it's a mystery. I should go right now in the Wayne County Jail for a juror not to return. Y'all know I must have had that happen to me one time for me to understand. So one time a juror thought they didn't have to come back. They could decide whether they didn't come back. All right. Everyone else, I'm gonna ask you a question. So it's 12 o'clock. What I'm going to do is we are going to you're gonna go to the jury room, and then you're going to decide, you're gonna choose your foreperson. You're going to decide a couple of things. So as long as you're in the jury room, I must have an officer stationed outside the jury room. However, don't worry about that. It is your decision if you want to deliberate through lunch. Now, it's 36 before I don't know if you watch stuff on TV, we're not bringing you in no lunch. It's not in the budget. During COVID, once COVID ended, they tried to do it, but then they really couldn't do it. It's up to you though, if you want to break for lunch to, actually go to lunch, or if you want to deliberate through lunch, or if you want to, like within yourselves, take up a collection and have lunch brought in, depending on how it's going. Like if you all agree, well, let's deliberate, everybody like pizza or something like that, we can place that order for you and have it brought in, but the court isn't going to pay for it, just so you know. So I do want to just know, normally the court breaks at 12:30 for lunch. If you decide you're going to deliberate through lunch, I will allow you to do that. And then the officers will just take turns on who goes to lunch. Somebody will just have to, be outside the jury room. And then I will be in my office if you deliberate through lunch so that I can, read if it's a note comes through that requires my immediate attention or something like that. I think I addressed everything. All right. Any questions for me before? I am going to let you do your voucher, but not just yet. So go to the jury room, pick your four-person, let me know what you're going to do in terms of breaking for lunch. If you want to go now, or like if you're just going to try at 12:30, whatever, you all just let me know. So that'll be your first discussion. You're going to get a jury book with numbers on the front. It's nothing special about the numbers. But the only thing in the jury books are the, jury instructions, and in fact, all of the jury instructions, so the ones that I read in the beginning, middle, and the end. But if you're looking specifically for the ones that I just read, that's the 300 series. So when you look in your books, you're gonna see some say 1 point something, some say 2 point something. The ones at the end and stuff, they start with 3 point something. All right. You're going to be provided with the envelopes that you'll need to write me a note. And you don't have to seal the envelope, but at least close it, put the back in, and don't write on the outside of the note. Okay, we're all set.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.